to have a detailed discussion on the implementation of 10th schedule of the Indian Constitution. Sakshi Education has invited two eminent speakers. The speakers are Dr. K. Vinay Kumar, Assistant Professor of Political Science from Maharashtra National Law University, Aurangabad, and Mr. Nishit Ranjan Chaki, Assistant Professor of Law from KCC Institute of Legal and Higher Education, Delhi. The first speaker of today's webinar is Dr. K. Vinay Kumar. Dr. K. Vinay Kumar is working as an Assistant Professor of Political Science in Maharashtra National Law University, Aurangabad. Before joining Maharashtra National Law University, Aurangabad, he was working as an Assistant Professor of Political Science at Geetam. He has more than 8 years of teaching and research experience. Currently, he is heading a Center for World Affairs at the university. He has 3 edited books to his credit, titled The Elephants Rise in the East, Navigating India's Foreign Policy in an Emerging Multipolar Asia, Terrorism and Technology in the 21st Century, Issues and Challenges, Global Geopolitical Impacts and the Dynamics of Indo-Pacific. He has presented papers at national and international conferences and contributed chapters in edited books. His areas of interest lie in energy security, renewable energy, climate change, terrorism, Indian foreign policy, and space militarization. Dr. K. Vinay Kumar frequently appears on international news channels such as AI Carrera, Ashraf News, and Bloomberg Dubai to discuss various global issues. Now I request Dr. K. Vinay Kumar to speak on understanding the anti-defection law and political party dynamics in India. Welcome, Dr. Vinay Kumar.
Thank you. Thank you very much, sir, for introducing me. It's my pleasure to be a part of the discussion today. As I'm very happy to be a part of this discussion, and I'm thankful to the Kotredi sir and ICFI group of institutions, and along with the ICFI group of institutions, I'm thankful to the Sakshi Media Group for inviting me to be the part of this wonderful discussion. And thank you once again for giving me this opportunity. So, if you permit me, I would like to share some of the slides to make sure that it will be visible for the people to understand it in a better way. Today, let us discuss about the anti-defection law in India and how this concept of anti-defection has emerged, and what are the political factors that led to the emergence of this anti-defection law. So initially, if we look into the freedom struggle, as rightly pointed out by Kotredi sir, that the freedom that we have gained from the colonial empire or the colonial regime during the period of the struggle for freedom, every party, regardless of their ideas, their inclination towards the ideologies, they were on one aim, that is to make sure that India gets freedom from the clutches of the colonial empire. So, keeping aside all the all the differences, all kind of inclinations, all kind of ideas at bay. So, what is the historical background for the emergence of this anti-defection law in India? I was just emphasizing and rightly pointed out by Kotredi sir that during the colonial regime, every political party, regardless of their inclination and ideas, all were with an idea that we need to get freedom at any cost. So, keeping aside all those ideological inclinations and party affiliations, whether it may be communist, whether it may be right, whether it may be extremist, or what it may be, keeping it aside, they started with an aim to free the country. But after the liberation of the state from the colonial clutches, it has come to essential thing that we need to have a democratic setup. In a democratic setup, the political parties play an important role, and the political parties, especially after the independence, though the Congress initially stated that it would not going to be a political party by it was stated by the Mahatma Gandhi that it would not be a political party after getting the freedom. But this was not the case once the freedom was achieved by the Congress party. And it was an essential at the point of time that there should be a leader. There should be a leader who is stick to the values, sticks to the ethical principles, so that they can lead the country towards a proper direction. And this has, in fact, maybe turned the Congress party toward to take a turn to be a political party. Now, once the Congress become a political party, majority of the people have joined the Congress party, and and they captured majority of the seats in the first general election, that is in the 1952. Though there were some independents and some political parties, but they could not get any substantial majority in either state legislative assemblies or at the national level in the parliament. This was the case in 1952 and 1957 and 1962, and the turn of events has come in the 1962. In the 1962, if you go back to the political history of India, because of the huge policy lapses, crop failure, and corrupt practices of the Congress government then, these all have led the people to look for an alternative. Now, in the fourth general elections that were held in 1967, during these general elections of 1967, if we look at the party configurations or the number of seats that each party has got, this is the first time when the Congress could not enjoy the substantial majority in the parliament. Though it has got a majority, but it was not a two-third majority which it has enjoyed in the previous elections. So we can consider that the 1967 election, that is from 1967 onwards, there has been a scope for the defection, more defections. If you look at the parliament configuration in 1967 general elections, the Congress got 283 seats, whereas the Swatantra Party, which is another party that has got 44 seats, and the Jana Sangh has got 35 seats. In fact, there were independent members, those have contested and got elected also. And successfully, the Congress government has installed its government at the national level. But at the state level, it has faced the troubles for the installation of the governments led by the Congress party. In the fourth general elections, when almost 16 states went for the election, out of the 16 states, majority of the states, that is half of the states, have been lost by the Congress party. The Congress could form the government only in 8 states out of the 16 states.
Only 12 participants.
So, the Congress could secure, half of the seats which it has contested, half of the states which it has contested. For example, I was just emphasizing that before 1967, it was enjoying a considerable majority at the central legislature and also at the state legislatures. But in the 1967, there was a turn of events, and this was not the case in the state legislative assemblies, ranging from the Bihar, Punjab, Madras, and other places. The Congress government has lost its seats in these legislatures. So, if you take into consideration of the figures that the Congress has been deficit to form the government, in Rajasthan it has been short by 4 seats, and in Punjab it was short by 5 seats, and in UP it was short by 13 seats, and in West Bengal, it was short by 14 seats. And in Bihar, which we are going to discuss further about this, Bihar situation and what led to the defection in Bihar. So Bihar was short of 32 seats to form the government. The simple majority I'm talking about. So, nearly after 2 months of political drama by the Congress, somehow it has managed to fetch the 4 seats in Rajasthan and form the government. But when we look at the other states, it was difficult for it, especially the Punjab, especially the Bihar, especially the West Bengal, and these states have faced a lot of problems in the formation of the government. Let me give you an example of the Bihar. If you take the case of Bihar, in Bihar, the case of anti-defection was unraveled in the 1967. Now, in case of Bihar, there was around different parties that have contested. No single party has got the majority to form the government. The Samyukta Socialist Party has emerged as one of the largest party in the state of Bihar, but it could not reach the majority to form the government. So, along with the Samyukta Socialist Party and Samyukta Vidyarthi Dal and other parties have come together and formed a government with 14 ministries. And once the government has been installed, the people who haven't got the portfolios, either the ministries or the important portfolios, or it maybe, these people started to look for the alternatives. So what happened in these people started to look for the alternatives, and as a result, the government has collapsed in the Bihar. Now, the dissatisfied rebel MLAs, we say, got divided from the government and they have formed Soshit Dal. So this Soshit Dal, along with the Congress party, has formed a government in Bihar after a year. That is from 1967. Almost in 1968, the Congress and the Soshit Dal has formed a government. But this government could not succeed for a long period of time because of the dissatisfaction that has been expressed, that has been there in the people who had contested in the elections and won the election, because they could not get this portfolios, important portfolios, and this has been continued until 1970s. And within this span of time, there was around 2 years where the Bihar drifted into the political crisis. Sorry, and the presidential rule was imposed. So here, from the fourth general elections onwards, the concept of defection has come into the prominence. It doesn't mean that earlier there was no concept of defections in the Indian political scenario. Earlier there was there, but not so prominent as it has been seen after 1967. So if you look at the data that have been provided on the screen, hope you would be able to see it. So between the fourth and fifth general elections from 1967 to 72, out of the 4,000 legislators, nearly half of the defections have taken place in the country. That means out of the 4,000 legislatures at the central level and at the state level, nearly 50% of the population have crossed the floors, have crossed, defected from one party and went to the other party. Now, what are there was a private member bill that was introduced to overcome this kind of defections in the near future. In the 1969, Venkata Subbaiah has introduced a private member bill to make sure this kind of immoral acts cannot be allowed by the parties, the respective parties, and there should be a code of conduct that has to be imposed by the legislature on the elected members of the parliament and the state legislatures. So this has come to the discussion in the 1969, and initially there was a code of conduct, but it has been referred to the committee. A YB Chauhan committee was framed, and this committee has worked for nearly 2 years, and it has submitted its report to the parliament in 1969. And in 1969, there was a discussion for a bill that has to be introduced in the parliament to curtail these defections. Now, though almost all the parties, regardless of ideologies, have consented for the enactment of this particular bill, but because of the midterm elections and because of the political crisis that India has faced from 1975 to 77, and then there was a Janata Party government that could not withstand, and after that, in 1985, they built a consensus on the Anti-Defection Law. What are the main aspects of this Anti-Defection Law? This anti-defection law, if you look at the etymologically, that defection means crossing over the floors. That means if a person X or Y, he was elected or representing one political party or an organization, and upon election from one particular political party, he has crossed to another political party on which he was not elected. So defection means going from one political party to another political party. So it has been introduced by the Prime Minister, the late Prime Minister Rajiv Gandhi, and it has come into force on March 1st, 2025. And it added one more schedule to the Indian Constitution, that is the 10th schedule to the Indian Constitution. What are the various provisions of this act? What exactly the gist of this act or the essence of this act? The act provides that if any member of the parliament or a legislative assembly fall vacant in the following terms. That is, if a member has been elected from one political party and he has joined other political party, then his candidature in the central legislature or the state legislature will be fortified. He cannot be a part of this particular legislature until and unless he resigns to that particular seat and go back to the constituency for the election purpose, and he has to contest the elections and come back again as a member of that particular party wherever he has crossed to. Now, there is one more provision that has been included in this 10th schedule, that is, in case if a party X or Y is issuing a whip to all the members of the legislative assemblies or the parliament, that in case of the discussion of an important bill, or in case of any in case of no confidence motion that has been moved in the legislatures, then it is the responsibility of the particular member to which he or she belongs to come and present in the parliament or the legislature to vote in favor of that particular bill according to the wish of the particular political party which he represents. And in case if he is absent for voting, or if he acts contrary to the whip that has been issued by the party, then he has to be disqualified from that particular legislature. There is a provision which there is an exception, of course, that the concerned person has to give an explanation to the concerned party within 15 days. In case if the party is satisfied with the reason that has been expressed by that particular member, then he can be exempted from that particular action. And also one more factor that has been added into this anti-defection law is that in case if a member who has been elected independently joins any political party, or if a nominated member joins any political party after the 6 months from the date of his oath. It means if I been a member of a legislative assembly or the parliament who has been nominated by a party X, if I'm joining any political party after the 6 months of my oath taking ceremony, then it is deemed that I am disqualified for the for being a member of that particular legislative assembly or the parliament. Now the question comes is that there are some few exceptions to this. This is where the most of the political parties have been facing the problems after the anti-defection law has been passed in the country. That is, the exceptions are that in case if there is a split in the party, that is, in case if 1/3 members of that particular party uh, has dissociated themselves from the political party to which they belongs to and forms a separate group, then then there is there is no action that has to be initiated against the members of a separate bloc that has emerged from the split of the original party. Now, you take the case of the recent Maharashtra political crisis, where the Shiv Sena Shinde party has dissociated itself from the main Shiv Sena Uddhav Thackeray party and formed a new entity, the Shiv Sena Shinde faction. So, in that scenario, there is a possibility that these members should not be disqualified from the legislative assembly or the legislative assembly, or in the case of parliament that might be happen. In case of parliament, if you take into consideration about the formation of the VP Chandrasekhar government, the Prime Minister Chandrasekhar government, when the VP Singh government has a majority in the parliament, the Prime Minister, the late Prime Minister Chandrasekhar ji has had a difference with the VP Singh government, and he had a split, and majority of the people have joined the Chandrasekhar government. The Prime Minister Chandrasekhar ji had formed a government, and of course, this government could not stay for a long period of time. It was there for 232 odd days. But in such scenario, the speaker, or the deputy speaker, or any designated member of that particular party of that particular house has no right to disqualify these members. At the same time, in case if the 2/3 member of the particular party gives the consent for the merger of that particular party into another party. For example, to take the case of the Prajarajam party. Now, the Prajarajam party, hope you remember that in the Telugu states, the Prajarajam party was formed by this the film actor, the Telugu film actor called Chiranjeevi. And later on, he was satisfied with the portfolio that was given by the Congress government, and with a coalition with the Congress government, initially he has merged his party into the Congress. We all know that situation or circumstances or what it may be. Now, there is one more thing, that is resignation of the speaker, deputy speaker, chairman, deputy chairman from the party membership. Now, in case if a member of a X party has been elected as a speaker of a house, or a deputy speaker of a house, or a chairman of a house, or deputy chairman of a house, now he has to resign to his primary membership of that particular political party, because as we know that that this position of the speaker and deputy speaker and chairman and the deputy chairman is neutral and it should not be inclined to any of the political parties. Now, let me explain you the contentious issue of. Okay, let me explain you the first case that has come after the this anti-defection law has been enacted. Now, the Speaker of the Kerala has got an opportunity to deal with the case of disqualification under this anti-defection law in 1985. In 1985, against the PC Thomas. The PC Thomas originally contested from the Democratic Janata Party in 1985, and he later on shifted his affiliation to the United Kerala Congress in February 1985. Considering the situation, the Democratic Janata Party of the Kerala government has given a letter to the speaker stating that that person, the PC Thomas, has to be disqualified under the anti-defection law. But as I was just explaining you earlier, that this act has come into force on March 1st, 1985. So this incident or this act has been committed by the PC Thomas in 1985 February, stating that the act has come into force on the 1st of March 1985, and this act of affiliation, change of affiliation, has happened in February 1985. So the speaker has absolved this issue, and there was no action that has been initiated against the PC Thomas. And after passing this, let me explain you about this paragraph 7 of this anti-defection law. The paragraph 7 of this anti-defection law clearly states that the speaker or the deputy speaker, being a neutral party in the house, either it may be the central legislature or the state legislature, it is the responsibility of the speaker to take an action on these acts which are committed by the members of the legislatures. The paragraph 7 states that the speaker has an authority to decide the case regarding the disqualification of the legislatures, disqualification of the legislature either in the parliament or at the state legislative assemblies. But this has been turned into a lot of controversies. As we have discussed just now, that the seat of speaker or the chair of the assembly or the chair at the parliament, the procedure that need to be followed for initiating any anti-defection process against the member of a legislative assembly or the member of parliament is that the particular party to which a candidate belongs to has crossed the floor. That particular party has to submit submit its request to the Secretary General of the Parliament to initiate the action against the member who has crossed the party. Now, it is the responsibility of the speaker to make sure that the party who has been crossed the floor has to reply to that particular letter which has been sent by the speaker within 14 days of the recipient of that particular letter from the speaker. But this process has been again and again pointed out that this process has been not followed in any of the defections that takes place at the state legislative assemblies or at the parliament level. If you take the case of the state legislative assemblies, the speaker of the state legislative assembly has to initiate the proceedings immediately after 14 days. But you can look at the different situations either in the state of Telangana, in the state of Maharashtra, in the state of Haryana, or either in the state of Goa. Goa, especially from 1991 to 1999, there were around 11 governments that have been formed in the entire decade of from 1991 to 99. 11 governments have been installed in Goa. So this is how the defections are more prevalent in different state legislative assemblies. And the controversial aspect is that the speaker, who has to be a neutral party or a neutral member to take and decide the cases in case of defection, being a political representative, either it may be the case of any state, the party whichever that gets the majority would be appointing the speaker of that particular legislative assembly. Now, in that scenario, it is quite surprising for anyone to know that the speaker would act against the party which he or she is representing. So this is what the contention is, that being a member of that particular party which gets the majority and being appointed by that particular party which gains the majority, it becomes very difficult for us to understand that how a speaker will act against the a party which is ruling and which has appointed him to the chair. So this has been contended by by the members of the opposition now and then, again up to the recent the states of Maharashtra, the governments also. In fact, the speakers were not being the neutral is one of the significant aspect of this anti-defection law, where the speakers started to act in favor of the ruling governments. During the TRS government, for the sake of a better understanding, during the TRS government, the Congress party, majority members of the Congress party have given representation to the speaker, stating that the Congress party has to be dissolved into the TRS party, and the Congress party has initiated proceedings against the members who have given a representation for dissolution of the Congress legislative party into the TRS party. But no action has been initiated for nearly 10 years or so. So this itself reflects that what kind of defection defection law has been implemented in the legislatures. Now the contention is that if you understand the various aspects of this defection, for example, we may say that as argued by Palkiwala, that in case if a party member, if an MLA or MP has changed his ideas or has been undergone a shift in the ideology from left to right or right to left or what it may be, so doesn't he have a right to express his views in the parliament or in the assembly, or doesn't he have the right to join any political party? That's the issue. That Article 19(1)(a), B, and in fact C, that is freedom of expression. If we look at the acting of a member in contrary to the party directions, his freedom is rightly curtailed. The freedom is rightly curtailed. He cannot express the views that he has in case it differs from the directions of that particular party, which is the party belongs to. And other factor is that he has a right to join any group. And 19(1)(a) and B says that he can act according to his conscience. And she says that he has the right to form any association. So, is it not in contradiction to the Article 19 of the Constitution? And in fact, if you look at this anti-defection law from a theoretical perspective, if you look at from the Machiavellian perspective, there is nothing wrong to shift the affiliations to any political party, because as we know that in political, as we read the Machiavelli, that he has clearly stated in the Prince that the personal morality should be differ from the private morality. So in that situation, being a selfish individual and being a person who wants to capture the power, there is nothing wrong from this perspective. But at the same time, if we look at the perspective of J.S. Mill in his text on liberty, if we look at an example of a family, now unless and until he is alone, and if he's not affecting the other member of the family or other members who are in relation with him, he has a right to do anything without entering into the rights, without transgressing into the rights of the other people. In that situation, to a certain extent, he has a liberty. But J.S. Mill emphasizes that, in case of his responsibility to the people who have elected him, in case of the people who has entrusted him by seeing the political party he or she belongs to, being a public representative, he has no right to cross the parties. He has no right to cross the party to the other party, because he is answerable to the people of the state. Because by crossing to the other party, by going over to the other party, it means it is affecting the rights of the people of the state who has elected him. So in this perspective, it is clearly true that it is against the morality, the public morality. It is against the democratic setup of the political, democratic setup of the constitution. But from understanding from a different perspective, looking from the party perspective, as we know that in India we have different parties, not a single party. There are different regional parties with various ambitions and ideological ambitions and personal ambitions. They have the different parties. We have different parties in our country. In case if a strict party affiliation has been not followed, in case if we allow the people to act in contrary to the decisions or the directives of the political party, it becomes very difficult for the legislatures to make the laws or to frame the laws or for the smooth conduct of the governance in the state. Because in case of the people given a freedom to act independently of the directives of the party to which he or she belongs to, so this will create a problem in the democratic setup. He or she will be voting according to the wishes and will of an individual, and as a result, no policy in the state would get the consent of the legislatures, a consent of the legislature, and no policy can be implemented in the state.